One of the most controversial episodes in Clarence Thomas's career was his confirmation hearings for the Supreme Court in 1991. Thomas faced accusations of sexual harassment from Anita Hill, a former colleague who had worked with him at the Department of Education and the Equal Employment Opportunity Commission. Hill claimed that Thomas had repeatedly made unwanted sexual advances and inappropriate comments to her, such as asking her out, discussing pornographic movies, and describing his own sexual prowess. Hill's allegations were leaked to the press after the initial hearings had ended, and the Senate Judiciary Committee reopened the hearings to hear her testimony. Thomas vehemently denied Hill's charges, calling them a high-tech lynching and a smear campaign orchestrated by his political opponents. He said he had never harassed Hill or any other woman, and that he had only engaged in friendly banter with his coworkers. He also questioned Hill's credibility and motives, suggesting that she was either lying or suffering from a mental disorder. He accused the committee of racism and sexism, and said he was being persecuted for his conservative views. The hearings were televised nationally and captivated the public. They exposed the deep divisions in American society over race, gender, and politics. They also sparked a national debate on sexual harassment in the workplace and inspired many women to come forward with their own stories of abuse. The hearings were widely seen as a turning point for the women's movement and a catalyst for more female representation in politics. The Senate ultimately confirmed Thomas by a narrow margin of 52 to 48 votes, making him the second African American justice in history. Thomas has since become one of the most conservative and influential members of the court, often writing dissenting opinions that challenge the status quo. He has also maintained his silence on the Hill controversy, rarely speaking about it in public or in his memoirs. He has said that he has forgiven his accusers, but has not forgotten what they did to him. Clarence Thomas is one of the most prominent advocates of originalism and textualism on the Supreme Court. These are two related but distinct approaches to interpreting the Constitution and statutes. Originalism is the idea that the meaning of the Constitution should be based on the original understanding of those who wrote and ratified it, not on changing social values or judicial preferences. Textualism is the idea that courts should rely on the plain meaning of the words in a statute, not on legislative history or policy goals. Thomas developed his judicial philosophy of originalism and textualism through his personal and professional experiences, as well as his study of history, law, and political theory. He was influenced by his upbringing in rural Georgia, where he witnessed racial discrimination and segregation, but also learned to value hard work, self-reliance, and personal responsibility. He was also influenced by his education at Holy Cross College and Yale Law School, where he encountered different perspectives on law and justice, but also faced prejudice and skepticism because of his race and conservative views. Thomas's judicial philosophy was further shaped by his work in the executive branch under Presidents Ronald Reagan and George H. Bush, where he served as Assistant Secretary for Civil Rights in the Department of Education, Chairman of the Equal Employment Opportunity Commission, and a judge on the U. Court of Appeals for the D. Circuit. In these roles, he developed a skepticism of federal power and a respect for state sovereignty and individual rights. He also became familiar with the challenges of interpreting and applying complex statutes and regulations. Thomas's originalism and textualism are evident in his opinions on various cases that have come before the Supreme Court. He has often dissented from the majority when he believes they have departed from the original meaning of the Constitution or the plain meaning of a statute. For example, he has argued that the First Amendment does not protect flag burning, that the Second Amendment protects an individual right to bear arms, that the Commerce Clause does not authorize Congress to regulate local activities that affect interstate commerce, that the 14th Amendment does not incorporate the Bill of Rights against the states, that affirmative action violates the Equal Protection Clause, and that federal courts have no power to review state court decisions on federal law. Thomas's originalism and textualism are not rigid or dogmatic, however. He has acknowledged that some constitutional provisions are vague or ambiguous, and that some statutes are poorly drafted or outdated. In such cases, he has advocated for using other sources of evidence to determine their meaning, such as historical context, structure, precedent, tradition, and common sense. He has also recognized that some constitutional principles are dynamic and adaptable to changing circumstances, such as due process and equal protection. He has also shown a willingness to reconsider his own views when presented with new arguments or evidence. Thomas's originalism and textualism are not only methods of interpretation, but also expressions of his judicial temperament and character.